Good day. My name is Ryan King. I'm one of the senior legal advisors at SEESA Labour Pretoria.
Good day. My name is Johan Plessis. I'm also a legal advisor at SEESA Pretoria.
Today's topic, Johan, is an interesting one. It stems from the criminal law, in fact, and it's the principle of double jeopardy. So double jeopardy effectively is what we call a perfect defense to a charge of misconduct. I think let's just explain to everybody what double jeopardy actually is.
Yes, thanks, Ryan. So basically what double jeopardy is when an employee cannot be found guilty of two separate misconducts that's based on the same facts.
So in the past, an employee would be able to plead guilty to one charge and not guilty to the other on the basis that it's double jeopardy. Is that correct?
That is 100% correct. Like you mentioned, it is a perfect defense.
What employers have struggled with is that they often are told that you can't take disciplinary action against an employee for his misconduct and also then recover any damages caused by that employee's misconduct. Is that a fallacy or is it a mistake?
Ryan, that most definitely is a mistake. Obviously, taking into consideration what the basic condition says, and also a fair procedure must follow before any monies are deducted.
Quite correct. Section 34 of the Basic Conditions of Employment allows for an employer to cover reasonable damages caused by misconduct or negligence, for that matter, caused by his employee. Let's just explain what is a fair procedure.
Yes, Ryan. So basically, a fair procedure is when employer conducts a disciplinary inquiry with the employee to give the employee an opportunity to state his case as to whether or not he's guilty or not guilty, and also for a proper investigation to take place. Once that has been concluded and the employer has been found guilty of the damages or the so-called negligence, the employer may deduct the money from the employee's salary, taking into consideration what the basic condition stipulates. First of all, the employer can recover the entire amount from the employee. However, he's not allowed to deduct more than 25% of the employee's basic wage.
And it's important to note that that loss needs to be the actual loss. You can't put any ancillary damages or any inconvenience attached to the damage. It actually has to be a damage that is calculable and can be placed on record.
That is correct, Ryan. It's also advisable that employers sign an acknowledgement of debt with the employee that grants permission for the company to deduct the money as well.
Is there any case law that's attached to this principle that we can quote?
Most definitely, Ryan. In the Solidarity on behalf of Mohammed and the Air Traffic Navigation, basically stated that should an employer deduct money from the employee after proper investigation has been conducted, does not constitute double jeopardy within the constraints of the basic conditions.
So in the past, employers had to make a decision whether they approached an employee from the purposes of taking him to a hearing or issuing a warning for misconduct or recovering those damages. Effectively, Section 34 of the Basic Conditions of Employment Act allows an employer to do both. And that's the principle we're discussing today. Is that correct?
That's 100% correct, Ryan.
Good. Thank you, Johan. It was a very interesting topic.
Thanks, Ryan. Keep well. Stay safe.